who were granted bail in the previous circuit. One of them could be released, the other one could not be released because he cannot furnish the bail bond. We have filed a modification application, Your Lordship. It was filed on the 12th of December. Today was a returnable date, but it's not appearing in the list. Your Lordship may
It
consider.
was taken up earlier.
Yes, Your Lordship, the bail has been granted.
No, you are saying returnable date.
Today is the returnable. It's not there in the list.
Just check.
Great.
My lord, may I be permitted to mention a matter? This is against, it's a group 4 matter. My lord, the date was supposed to be coming on today. My lord, it did not come in the list. My lord, it may be kept in a supplementary or tomorrow in the top of the list. Group 4. Tax matter, it's against the. My lord, I want to appear in person. I came from Kolkata. My lord, it can be kept today or tomorrow.
It cannot be, sir. We will give the bail a priority. Here, the court is going to close. We'll see. We don't know. If it was a returnable date, it should have come. If it has not come, then we'll see.
My lord, it's a fresh application. It was supposed to be listed.
Oh, it's fresh
ma'am.
application. Then we'll see. Not in this circuit. You try in your next circuit. Yes.
My lord, the petitioner will be agreed because it will become infructuous otherwise, because
We don't know how it will become infructuous. A tax liability is always subject to adjustment. Where is the question of
my
it
lord, the
becoming
question is on
infructuous?
jurisdiction of the authority who has.
We are not
acted.
hearing the matter on merits. Cannot be a irreparable injury. You will get whatever you need to get. After the bail matters are over, then only we can consider, otherwise. Yes, call the news.
Item number 1, how for the stadium?
Why are you giving? We have not allowed the mention. You are for?
I'm for.
None for the petitioner. Not here when none appears for the petitioner. List on Monday.
Number 2, in this case, I'm for the state, your lordships. Earlier occasion, they have got ad interim bail.
Same order.
I'm saying for not today.
Not today. Not today. Not today. He wants today.
Thereafter, your order will be guided to be 20. My lord. My lord.
Number 3.
My lord, may I permit to mention?
No, you may not. Sorry.
Item number 3.
Lordship, I'm for the state lordship.
These cases everybody's. None appears. List on Monday.
Yes. Number 4.
None appears Monday.
Item number 5.
for the petition. Number Yeah, please, your lordship.
Yes.
Now, my lord, in this case, I've been intercepted on 5th May 2024. That is 7 months, 12 days. I'm in custody. Now, my lord, so from my little knowledge goes, the date of seizure took effect on 5th May 2024.
What is the seizure?
Seizure, that is 1,000 bottle of cough syrup, my lord.
10,000.
10,000 bottle of cough syrup.
1,000 or 10,000.
Now, my lord, seizure was effected on 5th May 2024.
Yes.
Now, can you see the inventory was done on 15th May 2024. That is after a lapse of 10 days.
Yes.
Now, my lord, the samples which were taken during the course of inventory was sent for examination for FSL on 21st May of 2024.
Yes.
And the report received on 23rd October 2024. It is a clear case of violation of the Rule 14 of the NDPS rule. That is the rule, my lord. That is the rule, my lord.
This is not mandatory.
Let me finish.
Let him finish.
Let
please.
me finish. No, in this regard, my lord, I want to draw your lordship kind attention on observation passed by the Honorable Court of the similar issue.
কত নম্বর?
395.
কবে dated?
Dated 2/8/2024.
My lord, in the context of citation what she has referred, I'm submitting two orders of the coordinate page on the same date by the same judges where there was a delay of 6 months and that has been rejected.
But we are relying on judgment. That
Same,
was the-
and after that, after passing this judgment, his judgment was passed on the same
Maybe,
day.
maybe,
This
but-
is
but that judgment cannot go infractuous.
same judge, after passing this judgment has considered it, there was a delay of 6 months, it is in the paragraph.
My lord. 155 days delay. One 155. But the report should be received by the, within the maximum period of 30 days. There is a 155 days. I think.
Yes.
Yeah.
That we can. Pare.
10,000, what is the quantity? What is the quantity?
10,000 bottle means near about 1,000 liter, my lord. One bottle, 100 ml.
100 ml.
It's a huge quantity, my lord. This cough syrups, they have been, these are distributed among the, sold among the youth, my lord.
Also within the commercial quantity.
Yes, yes.
Commercial.
10 bottles. Above 10 bottles is commercial.
About 10 bottles.
Yes.
1 liter.
And the entire mixture goes.
What is the substance?
It's a codeine,
Codeine mixture.
codeine mixture, the entire quantity will go, my lord. The entire,
Quantity will
yes,
not
yes,
go.
that will go. That is in the, Mr. Bhowmik, why you- And the citation,
It must be a mixture of many things including codeine.
yes,
We particularly in 10,000 bottles, even if codeine is separately quantified.
it is also huge.
In this case, there is no such, it doesn't appear that it is regarding a commercial quantity.
My lord. my
Well,
lord.
what sort of quantity was
They
there?
don't, please show us from the order.
And moreover, my lord, on this,
And so what the case is concerned, my lord?
You said it is commercial, not was.
No, my lord, give the 1 day accommodation. I
No,
will-
no, sir, this judgment we have seen.
But so for
We
this,
cannot add to this judgment. 10,000 liters of cough syrup has been seized, leading to the petitioner's arrest. Stop, it is not in dispute that the quantum of seizure is of a
my
commercial
lord, one
quantity.
indulgence, may I say?
Stop,
My lord, one indulgence.
is commercial.
Page number 33. Page number 3, line number 6, the last line. A paragraph number 6, last line. 37 is there. Bar of 37 is had been diluted. In a case of intermediate quantity, 37 has no application.
even then, it's the huge.
No. His lordship was used to ask me whether there is a commercial quantity or not.
Yes,
I-
that is there. That is there. The the submission is that the seizure was done on 5/5/24, and the samples sent to the laboratory on 15/5,
21st 5.
21/5, whereas the report has been given on 23/10/2024. Based on a violation of the Narcotic Drugs and Psychotropic Substances Seizure, Storage, Sampling and Disposal Rules 2022. It is submitted that the petitioner would be entitled to bail. Full stop. A specific reference is made to section 14 of the rules to submit that there is a time limit specified in the said rule, which mandates the report to be sent within 15 days from receipt of the sample. The same having been violated, the petitioner should be granted the privilege of bail. Full stop. In this connection, it is, reliance is placed by the petitioner's counsel on an order passed by coordinate bench in the case of Durga Soren and others versus, Durga Soren and others in CRM within bracket NDPS 395 of 2024. The current State Council, on the other hand, submits that the rule being relied upon is not a mandatory rule. To stop, the discretion to grant or not grant bail is required to be exercised having regard to the facts and circumstances of each case. Full stop. Upon considering the rival submissions and the judgment being relied upon by the petitioner's counsel, we find that we are of the opinion that the rule being relied upon is not a mandatory rule, and non-compliance of the same cannot ipso facto give the petitioner a right to be granted bail by removing the bar as contained
The petitioners is the husband and the wife. My lord, admittedly, my lord, 414, my lord, bottles of, my lord, contraband has been seized, my lord. They were riding a, my lord, scooty. From the, my lord, the scooty, my lord, two-wheelers, my lord, the contraband were seized, my lord. So, my lord, every formalities has been completed. I have been in custody for, my lord, 200 and, my lord, 10 days. But only, my lord, I am praying bail, my lord, on behalf of the petitioner number 2, my lord. She's the wife, my lord, having 2 child, my lord.
He was the pillion.
Petition
He
number
is a
one.
pillion writer, my lord. She was the
Number one.
pillion writer. 1, my lord. I beg of your pardon, my lord. Petitioner number 1.
Now,
My lord. Yeah, my lord, the children, sir, my lord, are now staying at a relative's house, my lord.
Should have thought of that.
My lord, I
For carrying the substance,
My
you
lord,
should have thought
my
of
lord,
that.
that was, my lord, beyond my knowledge, my lord. The husband was carrying, my lord. I was a housewife, my lord.
Your husband doesn't like your children. Yes,
my lord, this was from their joint conscious position, my lord. They are within their knowledge, what they're carrying, the contraband article. Interest is there.
where is it? It is in the,
Public place, my lord.
no, it is inside the scooter's compartment or somewhere.
My lord, it was in a Reebok bag, my lord.
Bag was carried.
They were carrying a bag where 100 bottles, another bag carrying, that is also 100 bottles, another bag carrying 214 bottles.
3 bags.
3 bags.
On a
bags.
scooty.
On a scooty, that means it's not a big bag that those can be placed somewhere that they cannot see. So in a scooty, 100 bottles bag is a huge bag. So they were within the knowledge that what they're carrying.
They have been apprehended in a marketplace.
Not in a marketplace.
My lord, in a near a tea garden.
Where is the seizure? Let us see. Please show us the seizure.
My lord. It has been signed by the independent witnesses. All formalities has been done.
No, that he has said at the outset that all from. What is the stage? How many charge sheet witnesses?
My lord, charge sheet has been submitted on 12th November, the last page of this meeting, my lord, last page. 13 charge sheet.
13.
Only 13.
Why? So many,
Sir,
all
the
party, police
Two
party.
independent witnesses. Then the. Police, not all police personnel. The forensic.
Two of the seizure list witnesses and the other police person.
Police personnel, the complainant is there, police personnel, and the other witness is there, the forensic. Examiner, the official because he has done the invent, she has done the invent. The certification has been done right. It will not take much time.
Conclude it expeditiously. The learned counsel for the petitioner as well as the learned counsel. Comma, at the end you write, failing which the petitioner will have the right to renew his prayer for bail. Renew the prayer for bail. You are here. Yes,
Lordship,
as played.
in this matter, Lordship, yesterday, we were asked to whether WPA or WA was issued. WPA was issued against that.
Next set.
By then,
WPA, next set. None appears. Monday.
item number 12, I don't know, I put the state part, I put the news right. I'm waiting for day after. Get the whole section.
You want on 19? As spread.
19 thing into Mari election. 18
As played next set.
Grateful, great. Number 30.
Not today. As played. No order, just not today.
Item number 14.
As played Monday. You can't fix a date for everyone on their date of choice. There has to be a system. This is not today. You can't stand here and say 19, 20, 21. This is not the way. Not today already.
Item number 15, after the petition number. In this case, on the basis of the law of parity, I am saying okay.
Hot pass over there. Remote turn on the super. Remote turn. Remote. Acha.
No recovery from him, no recovery from him, this petitioner also. Case number 16. In this case, in respect of that accused and missile, showing a conduct charges that been filed. No recovery was made from our end.
No, what is the prosecution case?
Recovery, contraband was recovered from the possession of some accused person who transferred my name and other. accused.
They have said that they have procured from you.
No, that's accused.
Where is that? Let us see.
In the similar situation,
Let us see first, then we'll realize whether it is similar or not similar, dissimilar. Ajay Mandal. You are Ajay Mandal. Vishnu Roy.
page number 11, line number 3. Page number 11, line number 3.
So they have procured from you. That is what we are saying.
They have made the interrogation, the persons confess that they are jointly loaded the same narcotics from other among them.
Narcotics. After narcotics, what is the word?
Narcotics substance from other.
From Ajay. Therefore, we are saying they have said they have procured. Yes. And in antecedents,
No, I'm not his case either.
have you stated in your application?
There is no doubt.
Huh?
There is no doubt. Given that. The one of that is the page number 60.
Yes.
But short pass over, series.
Find out. find out, just let him find. Well, we'll take it up at 12. Yes, next circuit.
Hold on, 3rd of December, it was rejected. Second time.
Matter number 17.
Not today.
One day accommodation.
Therefore, without his case diary, we should proceed.
One day.
Not today, we'll take it up tomorrow. Not today. Yes, yesterday also none.
Yes, Lordship. Nobody appeared yesterday. Original case diary, Lordship.
164 is there.
164 has been noted in the order granting interim bail. There is an interim bail granted earlier. The victim has stated about a consensual relationship earlier. Based on that, the interim bail was granted. He is not appearing.
Lordship, if matter fixed tomorrow, Lordship, I inform the other
Not
side.
today.
I'm for the petitioner, my lord. Lord, I'm led by Mr. Shobhit Mittal, Lalit, senior counsel in this matter, my lord. He has gone to, my lord, Chennai for some personal reasons. My lord, he will come on Monday, personally before your lordships, and he'll argue the matter. My lord, let it be placed on Monday.
Has prayed Monday, give data.
Grateful, my lord.
Grateful, Lordship.
Item number 20.
Well, I'm seeking a short pass over. Mr. Rai is on his legs before court number 3.
Not today, not today.
Lordship, previous item, kindly, CD is produced in previous item, Lordship.
This is the way your matter is over. Why anytime you feel like you will come and start making submissions? I was looking at you, you said nothing. Now when the next case is called, you are making a submission of an earlier case. Unique, yes, call the next case.
Item number 21. Item number 21.
Yes, you are appearing.
I'm appearing for on behalf of the petition.
Yes. I'm calling.
Thank you, Mr.
Yes.
We are in this case acting upon a complaint lodged by the defective complaint dated 2024. The police of football police station. Initially has started a case under section of 63 and 65 of the ICC. And in course of investigation on 16/6/2024, the police arrested this present accused petitioner, Your Honor, from the place named as Warmore under the jurisdiction of
16/6.
16/6, Your Lordship.
Then why you stated 17/6 in your petition?
Forwarded before the learned chief judicial magistrate on 17/6, Your Lordship.
See what you have said in paragraph 2. So which is correct? Yes, proceed.
Your Lordship, on the very date, that is on 16th June 2024, the victim girl was recovered. And for appreciation of my bail application,
What is the allegation? What is the allegation?
allegation that after we allured her, this petitioner taken her in a different place and stayed there for 2 days.
2 days.
Yes. Your Lordship.
Her statement has been recorded.
This from the date of her recovery.
Where is the statement? It is there.
Lord, I am holding the case diary, my lord. There is a 164 statement of the victim, my lord. This is
Net.
clearly stated, my lord. It's a Bengal written, my lord. After 2 days, she has recovered, my lord, and detained on a rented place. And there she was sexually abused by the present petitioner. Age, my lord, kindly. Mohammed Rahul is the present petitioner, my lord.
It was reported after 7 days from the date of.
Many times you will say that. Saying it twice, it doesn't become 14, it remains 7.
One more thing I would like to add, Your Lordship.
He also threatened the girl, my lord.
Let us see. Statement we gave. Don't worry. We are not in haste.
Married man, my lord. He's married. Married man. With having child also.
What is this, the man's age?
21 years.
He was examined medically or?
No, declined to go for medical legal exam.
And police recovered her.
Police recovered.
She came on her own or police recovered?
Police
Recovered,
recovered, but it is for this.
From where?
From the jurisdiction of Malbajar police station.
No, from where? On the
Far more,
roaming on the
roaming
road.
on the road. Far more. That's why I am.
She was roaming on the road.
Yes.
Under his custody.
On 16/6, that is more than 6 months.
At present, my lord, at the time of recovery, accused is present on the spot, my lord.
Where is the medical report?
Medical report, my lord.
Medical examination.
Ten, medical report. Medical decline. And that time, my lord, she was mentally disturbed.
She was recovered.
Yes, so
Petitioner and the Leonard's APP or PP?
Well,
Yes, APP. The petitioner has been apprehended on 16/6/24 upon recovery of the alleged victim. Who is the complainant? Her mother?
Her mother.
The complaint was lodged by the victim's mother alleging that she left home without intimating anyone. And suspecting that the petitioner has taken her away. Stop. It is submitted by the learned counsel for the petitioner that from the narration of the prosecution case, it is apparent that the parties were known to each other from before and were having some relationship. Stop. The
My lord, in this application, my lord, Supreme Court has rejected their prayer for anti-safety bill. This is the third time, my lord, they are doing it. Kindly read the order, because this application is not maintainable. That is why they are not doing
the application for anticipatory bail.
My lord, it's the bail matter, my lord. Actually, it was my mistake. I just checked my calls. Pardon me.
None appears for the petitioner. So after surrender, the Supreme Court has said that he can move
Yes, my lord.
list on Monday.
It's Monday.
I'm for the de facto, my lord.
Mr. Ganguly is appearing on behalf of the state bar. He is moving a matter before the court number 2. Kindly make it short possible.
NDPS.
No, my lord.
Both are major.
That is not the case, my lord.
We'll
Both
hear
are-
you also, we'll hear you also. Yes. What are the offences are under which sections?
Allegation of rape, earlier 370.
Any medical? Any statement under 164?
Yes, my lord, statement has been recorded. And my lord, fact is not only promised to marry, the petitioner took the girl to his house, kept her with him for 4 or 5 days with the intention to marry her. After 4 or 5
Can you
days,
give us copy of the FIR?
FIR is, medical research.
Can you give us the FIR?
Apology, Your
No, we were informed, we have.
Lordship says page 8 is the petition.
She is herself the complainant.
Yes, my lord.
Page 8 is the petition.
Where is the FIR?
FIR, Lordship, first page, second page, maybe page number 2. After the.
You have stapled it in such a way that it's impossible.
Lordship, it counts this way, just now I have received. Page 37 is the 151st. Thirty-seven is the 164. 164. 37, Lordship.
That is here.
Number 24. Number 25.
25, my lord, I am appealing for this state.
I am appearing for the complainant.
Affidavit of service on record. Yes.
Basically, my lord, she was earlier married, and one case is pending against her. She suppressed her earlier marriage, there is no degree of support, my lord.
There is a case pending earlier.
Against her husband, my lord. He saying that petitioner and the defendant have relationship, 4 years, and petitioner denied to marry her. Because my lord, she had already married earlier, and she suppressed, and one case is pending against her and her husband, my lord. There is no degree of divorce, nothing, my lord. She suppressed. I already annexed the order sheet also, my lord.
So against the earlier husband and in-laws, she has lost another case.
Suppressed the marriage.
No, my lord. The petitioner and the complainant.
After him, yes.
And I annexed.
You have annexed. Page 8. Page 8.
Earlier marriage, she was earlier married. For this reason, this marriage is not followed.
BB. Can you see the FIR?
My lord, FIR.
Yes. You annex the present FIR.
Written in Bengali.
And he's in jail. He's in jail.
Yes, my lord.
Since
66 days, my lord. Exact date, my lord, not-
more than 2 months.
Yes, my lord. 2nd of October 2006. 164
Second
statement,
October.
page 37 backside, my lord. Relevant portion.
Huh?
164 statement of the victim girl, my lord, page 37 backside.
What good is medical, the nature of allegation that she is making?
Yes. Charge sheet also, sir.
There must not be any sign of a struggle or any
No,
sign
no,
of injury.
No, there is not.
What's the victim's age?
Now, the age of the victim, my lord,
32 years.
33 years.
32
years. That's what
32 as per other voter record.
Medical report, medical report. Yes.
Defector complaint and the petitioner presently residing in the same village.
No, they were residing next to each other
And
in the adjoining house.
next year.
And
And
just-
they known, petitioner known their, he is left her husband.
Heard
Taking
counsel,
this advantage, they took a
heard
relationship.
counsel for the petitioner, the learned state council as well.
26, my lord, I am appealing for this.
Yes.
My lord.
Item number 27.
Yes.
Five earlier 498, 100, 302 earlier.
302.
302, one earlier. Now, charge submitted 85, 498 and 88, but this is 304. Charge submitted 498 and 304.
You are the husband.
I'm the husband, madam. 150 days, 150 days, madam, custody, madam. Charge sheet submitted, he committed suicide by 98, madam. Charge sheet submitted.
All the in-laws were made accused.
Yes, madam.
Main accused.
161 of the neighboring persons.
For example, whereas in here,
161, 161, this is the postmortem, 161 starts from page number 14.
He died in the matrimonial law.
yes. Charge sheet submitted, 150 days. I will forward to the
Within 5 years of marriage.
I give to hang him. Comment, please, and complain. Who informed him? Who informed him? Who informed him?
No, all were, after the incident, all of them escaped. And the brother of the deceased was informed by the neighbors.
Neighbors. And all in-laws have been allowed.
All of them. So that is one that cast doubt in the mind of the fellow. Why they have, if there was really,
No, the offense itself is presumptive. The offense itself is presumptive. You are the husband, you owe the prime responsibility. How much unnatural death in the matrimonial home within 5 years? And hardly 2 months.
Where had you gone? To have a morning walk?
no, you have given the CD of 28. Manik Burman. 27th of password, not today.
27, he has played not today. No, 26, 27 both.
अरे ठीक है सीडी ठीक है
Third learned counsel for the petitioner. Yes. You were saying something. Yes, third learned counsel for the petitioner, the learned state counsel.
No.
You're for the petitioner. Not today.
Your Lordship, I'm appearing for the petitioner, Your Lordship. The counsel appearing in this matter is unable to appear because his mother has broken her hands and she's undergoing surgery. So kindly keeps the matter in the next circuit, Your Lordship.
The application you not simplified, only the last but when CPI is
So when she appears, then we will make the submission. The learned counsel, MS Swenso appears online to submit that. The counsel who has to appear on behalf of the petitioner is prevented from attending the court proceedings on account of a medical emergency in the family. Stop. The learned have appeared on behalf of the respondents. As played by MS Swenso appearing virtually, the matter is adjourned to the next circuit.
Grateful, Your Lordship.
Your name.
Item number 31.
As played next circuit. The allegation.
You understand, see, it's an allegation under 302. It's a death of a police officer. What happened, my lord, the police, the petition officer is in a leader of the hills, some agitation are there. It's a case of the police that, my lord, they want to arrest him, they are in a hiding out. So there is some scuffling. And these all the
They
police.
had gone to arrest this petitioner.
There are other also, many, because they are the leaders, they are leaders and other supporters of Gorkha Mukti Morcha. And my lord, all the witnesses are the police witnesses. There's no independent witnesses. The allegation against me that, my lord, one officer died, my lord. My lord, I'm not going to die. One of the police officers died. Because the allegation is the only class of allegation is that the police, 3 groups, they attacked those, my lord, the three groups,
Rooms.
3 groups,
Groups.
3 groups, they attacked those, my lord, miscreants, alleged miscreants, including the petitioners. There's a firing exchange. The crux of the case is that, my lord, the police officer who died, he followed some miscreants in the river, having a knee depth water. And then somebody fired on him. So there the police says, one of the petitioners also fired. But these are police, police witness, but there is no independent witness. Next one you also can see, charge sheet was filed. So can say 2017 case was lost, my lord. Now charge sheet was filed, supplementary charge sheet was filed, so it's a investigation completed, my lord. 2021 I came back again, my lord. So many cases.
Came back means?
But I came back on the spot on Darjeeling, my lord, according to them. And you lost, I see.
So in the meantime, you were underground.
No, I was not underground, but there are many cases against me, my lord. So from the reports, it appears that in many cases I appeared. Some of the cases, the government discharged me. But so I have a 4 points ground, my lord. I'm not going to the case of 302. But the charge sheet was filed. It's a complete investigation. 2029, many cases against me. I appeared. Well, these are list of the cases, my lord. I appeared, and some of the cases I have been discharged by the state government. In that too. Can you?
You have served a copy of this list.
I'm giving. So, madam, many of the cases.
Have you given a copy?
Yes. So many of the cases, my lord, I've now after 2000, I appeared, I got the bail, and some of the cases, when the state government discharged me. And so, my lord, there is no scope of my absconding. Still, 2020, I'm in Darjeeling, my lord. So, your lordship, can I appreciate, my lord, I'm ready to face the trial. One of the cases, recently, my lord, recently one case, I faced the trial, and I was in a UPA case. I was. This is very bad. Well, I was acquitted. So, my lord, there's a 4 limbs of my submission. I'm not going to the, my lord, merit of the case. So, there's no scope of, my lord, further investigation. There's no scope of my absconding. I mean, here on any conditions, my lord, I'm ready to face the trial. But there's no charge has been framed. They said 78 witnesses are there, my lord.
Altogether, 78 cases.
78 witnesses.
80 witnesses.
Yes, 80 witnesses. So, my lord, there's no independent witness. It's a completion of the investigation. There's no scope of absconding. My lord, I'm coming for money. In earlier section 438, there's a provision that gravity of the offense is one of the consideration. As can you see on the new act, this provision is not there. Section 482 of the new act, can you see?
Absconding for nearly 7 years.
But you also appreciate, except what I said, my name is, I'm a Bimal Guru, I'm in the hills, there's agitation, there's a many, scuffling, many things, the political issues are there. So from 2020, I'm in Darjeeling, my lord. My lord, can you see my list of cases? I appeared, even I've been discharged, what I'm trying to emphasize before lordship, I've been discharged.
But in this case, total 27 charge-sheet there, and charge-sheet witness is 80. My lord, FIR date, my lord, including Bimal Guru, my lord, 9 is FIR date.
He is one of the name,
Yes, my lord.
one amongst the 9 named.
9, yes. And my lord, thereafter, my lord, charge-sheet submitted on first occasion, my lord,
20 January 2018.
25/1/2018. And thereafter, my lord, 3 supplementary charge sheet have been submitted, my lord. And the last
Three supplementary.
Yes.
yes.
In the first, my name was not there, second they have included my name.
First name is there, that is right. But and thereafter, my lord, next day it's for 6/2024 for appearance and WA. And my lord, the witness, my lord, all the witnesses, 161 statement of the police witness, that is right. But this is corroborated with the portion of the prosecution case. But it is a voluminous city, my lord. If there is any merit is concerned, my lord, I think there is no.
No, I'm not going to.
Other occasion, my lord, that is right thing, my lord. These 80 witnesses is there, my lord, is absconded, and last occasion the WPA proceedings they challenged and that has been turned down by the coordinated bench of this court, my lord, and
A single bench.
a single bench.
Has been turned down.
Yes, my lord,
Yes.
set aside.
Set aside.
Proclaim offender is set
That
aside.
has been allowed.
Yes,
not
yes,
the-
allowed.
And you have filed an SLP against that order.
Right now, my lord, there is no SLP, my lord. We are.
Find a letter in the file.
Yes, I have filed, my lord, on last occasion, my lord. We are initiated, but
At present, they have not
at
filed, my
present,
lord.
we are not filed, my
The
lord.
letter of 18/11/20,
Yes,
more than a month back.
yes, ma'am. Thereafter, no. But today, my lord,
What is the position in the other cases, this list that he has given?
other case, my lord, other case, my lord.
I give the list, my lord.
Yes.
Somebody I on the
That
bail.
is already discharged, my lord.
Oh, this contains a list of many cases.
Yes, yes.
And most of the cases I've got the bail, some of them are discharged by the state governments. This is the list of the. Either what I last act of opinions. Okay.
Why didn't?
4 cases, he was discharged.
There's a list of 6 cases. 4 years
I-
discharged. And what about the other 2?
This I got the bail. I got the bail, man. I appeared and got the bail. I given the.
No, it's not got anticipatory, it is surrender come bail.
I got bail.
No,
One is
see
anticipatory.
at serial number 1 and serial number 4.
And surrender before the
And what about 4? 4?
surrender and opted
There is a direction in your the order which has been passed by the Honorable Single Judge. He has directed you to appear before the
But
court.
this is, yes, and again, can you see this is another part. I can take my, can you see my order? Your lordship is correct. Can you come to page 143? The other line is there. The action of this court shall not forbid the present petitioner to approve the applicant for desired relief. So 438 is my lord. At page 143, my lord.
Hmm. 143.
Yes. Last 2 sentences. The direction of this court shall not forbid the present petitioner to approve the applicant from so desired relief. Court asked me to appear with the London magistrate and then has given me Judgment was full judgment was the 20. Hello, sir. I think it's a, it's really actual.
At serial number 4,
Yes, madam.
which page is annexure D?
I'm giving. Which one you are asking, madam? Four.
Annexure D, marked as D.
Oh, yes, I'm giving. Page 54, madam, running page 54. Sorry, madam. In the affair.
Paging in this, how can
You lost it, please, for this. Also, Joshua, please link. Madam, can you allow me, I'm sorry, madam. Joshua, please for me. Well, my says page is there, running page. Well, can you, Joshua, can you give me, I just indicate it. My lord is not page. Yours can, sorry, my lord. I'm giving my lord.
There is page number, but not in respect of this one.
No.
Some else.
Man, can you see D is 54 to 61.
It contains. page
Running page.
It contains page number 400, 300, 500,
Oh, it is
600.
only. Running page. Running page, this is in type of. Running page, what is it? I just indicating, my tell you, kindly excuse me, my lord. I just,
get it paginated, we'll take it up tomorrow. Get it paginated.
yes, ma'am. So you're saying allow me to include other two cases. I just included this. The other two cases I will include, but I am,
Please do it, not today.
yes, ma'am. I'm sorry, my lord, can you apologize me?
In fact, since it is being adjourned, you take instruction regarding this list. No, this list and the status of the SLP as well as the other two cases. Take down. Take down. The Land Council for the Land Senior Council for the petitioner submits that he will be handing over a list of 6 cases, a list of 8 cases wherein the petitioner has also been made an accused.
48. Number 49.
Yes. Is also not.
Next circuit, listen the next one. Come in the next circuit. Yeah. Point out. I will take the correct number. In today's. As registered as a local operator and the sum of money. My accused person, by the book person, has registered the Kidnapping, has registered the Kidnapping complaint and demanded the capital and state tax. And thereafter, 50,000 was taken from the back. This was the allegation. This the first this allegation was that the entire was registered. It is filed accused person and during the course of investigation. Person had approached before the honorable high court and by different order they have been their which was allowed and the petitioner was subsequently approached before your lordship after filing of the charge sheet. This is the lordship. I have managed the FIR as well as the charge sheet and some and the order. FIR is of which year?
And it will be also.
The FIR is of which year?
In fact, it's up to the 2030. But
2013.
30. Charge sheet was submitted on 5th of April 2024. 5th of April 2024. I have also relied upon two orders of the 48 page of the Honorable High Court at page 27 and 29 onwards. Where the 27 and 31.
When also they must have got in 13, 14. What are you saying?
But there was in the course of investigation.
Coming into 20 years after the police case, you are coming for an investigation because of 6 years, and you are seeking parity with someone who has submitted to the law within a year.
Because why I am very much because the recently was submitted, I came to know that data was registered. But prior to that, I was never was attempted to interrogate or nothing sort of. Pursuant to the submission of the after submission when warrant was issued, I came to know. That's why I approached for your.
2019.
The charge sheet. The
He's saying 24. 2019 charge sheet.
When was the charge sheet filed?
Charge sheet filed on 2024 of this year. That's why I'm coming to your lawyer. It's not that I was deliberately absconding and all.
Charge sheet in page number 21.
Yes. Page number 21, you are filed on 5th of April 2024.
36, 2019. Learned Counsel, is he submitting correctly?
Chapter 30th to 2019, no, that was prepared, but it was filed in the court on 6th of April 2024. I am ready for the record.
Produce a certified copy of the order sheet of the trial court.
Just tell the page number.
Order of the 29th of January 2025, where it has recorded that petition was valid.
Just now you said you are showing us an order, it has been filed in 24. Where is it show us? Why are you jumping to another date? No, made a submission, you are saying you are having the record, now you are jumping to another point and another date.
That is 24. Whatever, that is 24 on my application. Right hand side, right hand side. The corner area.
Lordship, that is 6/8/2024 for appearance and ER of WA. That means charge sheet had been previously filed and WA was issued. Warrant of arrest was issued, that means previously.
Right hand side corner also.
What is there in the right hand side?
It's the April 2024.
It's not there in our copy.
Not in our copy.
After getting the file.
That's why actually, here and whatever. Here and whatever.
এখানে দেখা যাচ্ছে
You have made a submission that charge sheet filed in 24. We are asking you to show this from the record. Show us.
Somehow not legible.
Then how did you make that submission?
I got this certified copy that.
So show us the certified copy tomorrow. Yes, come to my. Not today. Sure.
After the state.
About 52.
I'm for the state.
Yes.
Number 54.
326, 307, 25 and 27 Arms Act.
Second day, then none of them.
Next. Next.
Item number 55. Number 56.
Your Lordship, item number 56, kindly keeps it in the next circuit, Your Lordship. Grateful, Your Lordship.
Number 57.
I got the state, madam.
Oh, nobody is there. None of the next circuit. All the matter was called yesterday.
Number 58.
Next circuit.
Number 59.
My lord, I am for the petitioner. May I, my lord? May I, my lord?
Just a minute.
Lordship,
My-
one day
Just
accommodation.
give
Lordship.
us, just.
Case diary is not available, one day accommodation.
My lord, in that case, may it be kept on Friday 20th? Because one more, my matter is kept on Friday.
20th.
My lords, my lords, my lords.
Item number 60.
Lordship, I am put the petition. Lordship, in this matter, in the last circuit, Lordship, the present petitioner protected by the order, Lordship, to not to take any coercive step, Lordship. Lordship, the allegation of kidnapping leveled against the present petitioner that his
What was the age of the victim?
Lordship, more than around 20 years, Lordship. They got married. I have
Who is the informant? Who is the complainant?
father of the company.
He has also deposed.
Father of the
Victim
victim.
has also deposed.
Lordship, as per prosecution case, Lordship, victim not recovered.
But they got married, Lordship, before lodging this complaint, Lordship. They had love affair. They got married, Lordship. Lord, not with me, Lordship. Present petitioner is the principal accused grandfather, Lordship. He's 76-year-old. Whatever might be, has the victim girl been recovered or not? She's not. She's with the principal accused, Lordship. She's living in Delhi. Let the victim girl be placed. Thereafter, anything will be considered. Lordship, we informed Lordship, but they don't want to come because they scared about that they will get arrested. They are major. They got married. I have annexed the.
Let's see the FIR.
Yes.
I have annexed the marriage registration certificate. That is
You have annexed it.
Lordship, page 8. Annexure A2. They are major, they get married. And the date of marriage is the earlier to filing this complaint, Lordship. That is 5th of October 2024, they got married, and FIR was lost on 12th of November, Lordship. Lordship.
After the marriage.
After the marriage. As the father of the victim not agreed to that marriage.
No.
One cannot go through the FIR in the charge sheet, sorry, in the CD.
Yes, Lordship.
It has been stapled in such a way that one cannot go through the FIR.
Earlier occasion, Lordship,
Lordship, present petitioner is the grandfather.
You are beneficiary of an order, which casts an obligation on you.
yes.
We have provided, Lordship.
Where is that?
Lordship, we have provided the
Only
details of the VG to the IO, Lordship. We give contact number, they made.
Where is that? You must have tendered it.
Lordship.
Where is that?
Then IO may be called for, Lordship. Okay.
Why you are here? This was a duty cast on you. Show us that you have complied with this. That's all.
Lordship, we provide the phone numbers, Lordship.
Mr. Counsel, why can't you show us? Saying the same thing 10 times is not going to help you.
Lordship.
There is a duty cast upon you by the order. You are a beneficiary of that order. We are asking you to show us, come clean, that you have complied with this. Show us what you have done. Where is it? You have specifically stated that you will supply the details of whereabouts of the principal accused and the victim. This is your statement recorded in the order. Show us where you have given it. That is all. Nothing.
Lordship, then
Nothing remains to be argued now.
Lordship, then kindly fix the matter on Friday. In the meantime, I'll provide a
For complying with the obligation cast in the order dated 6/12/24, the petitioner's counsel seeks an adjournment to 20 to stop list accordingly.
And Lordship, the stay order may be extended till the next hearing, Lordship.
Not
To take any coercive stay,
It's not limited. It is an open-ended order.
Lordship. Yeah, I agree. Grateful, Lordship.
Lordship, I'm for the petitioner. Lordship, praying for next circuit, Lordship.
Yes.
Great.
Item number 62.
I'm for the state. Lord, I'm for the petitioner. My lord, here, my lord, the wife is the, my lord, the petitioner. My lord, kindly come to page 11. That is, my lord, the complaint that has been lodged by this instant petitioner on the ground that she was subjected to torture, cruelty, harassment only because of she gave birth to a female child. In this case, my lord, after lodging this instant complaint under section 498A, my lord, the husband, my lord, committed suicide. The husband committed suicide after, my lord, institution of this complaint, after several months. And my lord, the entire allegation has been, my lord, cast against me. Page 11, my lord, kindly have a look. That is the complaint lodged by this petitioner. She was, my lord, ousted out from her matrimonial home as because, my lord, she was subjected to cruelty on the ground that she gave birth to a female child. It has been categorically, my lord, stated in the written complaint. My lord, this complaint was lodged on 29th of March 2024. And my lord, the alleged incident against which I have been, my lord, prosecuted, the husband committed suicide. That was on, my lord, 11th of June 2024. My lord, 11th of 29th of March 2024. That was lodged by this petitioner.
The date of suicide.
My lord, the date of suicide is, my lord, my lord, on 4th of my lord, June 2024. The 8th of June, my lord, 2024. My lord, he committed suicide as my lord.
What is the cause of death?
Lordship, antemortem hanging, antemortem poisoning. And Lordship, the important fact is the way my learned friend canvassed the story. That is actually not the fact. The fact lies here that the husband, the victim, was residing with his wife at the paternal house of the wife. And there he committed such thing. This is not the case that the
Is there any dying declaration?
there is no dying declaration. Actually, the case was first registered under section 307 because there was an allegation of administering the poison.
How many days? How many days the person was admitted in the hospital?
On 8th June, the person was admitted to the hospital. The de facto complaint, that is the father of the victim, he got information on 9th June and subsequently expired on 10th June.
The wife who took him to the hospital and
He was residing with his wife only, and he had the wife.
yes,
Uh,
wife is taken to the hospital and got him admitted and ensured that he was given the best of treatment. Which is obvious from your allegation itself.
Lordship,
Because
kindly
he has passed away after 2 days. You have also come after 2 days.
Lordship, actually, the father, the de facto complainant got the information letter.
Information late.
Letter.
But still, the fact remains that for 2 days you were not
He was,
there.
yes, he got the treatment. That is the truth. But Lordship, kindly peruse page 5, the statement. The statement of father and mother on page 5 and 6,
Yeah.
and subsequently on 12, the
Father and mother means
of the
yourself.
victim. Of the victim, and page 12 is the independent witness.
Obviously, they will say the same.
And page 12 is the independent witness.
Who is the independent witness?
Neighbor of the
said?
petitioner, neighbor of the petitioner.
What has he said? Read. Neighbor of the petitioner.
Yes.
What is, you mean from the father's neighbor near the father's house?
No, neighbor of the here the petitioner is the wife.
Oh, neighbor of the petitioner.
Neighbor of the
What has he
petitioner.
said?
They came to know that the victims sustained physical and severe mental torture, and subsequently
they came to know.
They came to know. Obviously, hearsay.
Hearsay evidence.
Obviously, hearsay, because it is not possible that always the neighbor will see the incident.
Is anticipatory.
Anticipatory, and the investigation is still on. No, sorry, Lordship, charge sheet submitted. Sorry.
Well, charge sheet submitted.
Sorry,
My lord, the surprising fact is that, my lord, the complaint that has been lodged by the petitioner with regard to, the cruelty and harassment, she, didn't not utter a single, narratives against her husband. It was only against her in-laws. If your lordship kindly have a look on, the narratives, my lord. She had no aspersion directly against her husband. It is only against her in-laws.
Lordship, the petitioner.
How long back he had gone to this his wife's house?
My lord,
he had gone.
My lord, with regard to that, my lord, with regard to that aspect, my lord, I have no information or instruction, my lord.
It is not apparent from anywhere that when.
No, my lord, no. But she was ousted out from her matrimonial home
on third.
The petitioner, my lord, used to reside at her parental house.
On 3rd April 2024.
And they had a child, my lord. The child was a female child. And my lord, due to the take care of that child, my lord, the deceased used to visit her in-laws' house.
It is clearly stated on 3rd April.
Deceased used to visit her.
Deceased means the husband, my lord.
The husband was residing in his in-laws' house from 3rd April.
Is there anything to show since when he was residing?
Yes.
Since when he is residing?
3rd April. 3rd April 2024.
That is from the hearsay evidence, my lord.
That is not hearsay. That portion is not hearsay.
Where you are telling us?
So statement 161 statement.
Of
a neighbor of the
that neighbor who has heard everything.
I heard everything. Not someone. আসামি চিত্রা রায় বাদী পরিবারের সঙ্গে ঝামেলা করে তার ছেলেকে নিয়ে শ্বশুর বাড়িতে বাপের বাড়িতে চলে আসে from 3rd April 2024.
বাপের বাড়িতে চলে.
Earlier, a criminal proceeding has been filed.
My lord, with regard to this petitioner's my lord, complaint.
From the 6th line of the FIR.
Yes, my lord. It has been stated that before 2 months back, my lord, she left the matrimonial home and she instituted a criminal proceedings against the in-laws.
That is the 498A1.
Yes, my lord. Yes.
Are you the first person to seek bail?
My lordship.
Are you the first person to seek bail?
Lordship.
Anticipatory bail?
Lordship. My lord,
another accused was previously arrested and subsequently he was enlarged on bail after arrest. That is post arrest and there is a pre-arrest.
Who is the other person? Father.
Father-in-law perhaps.
Yes, my lord. The father and the mother, my lord.
পিতা না দেবী চিকুরা কি পিতা ওই
And my lord, the pathetic situation.
And this case has been instituted on which date?
11 June 2024,
After the death.
after the death.
So you are saying earlier it was under 307. You said that earlier it was lost.
Yes, the
under-
case was registered under 307.
What is the date? That's why we are asking you. On 11th, how it can be 307? On that day, he has already died.
And my lord, the surprise.
Please let us
Lordship.
clarify.
Lordship, justice, Lordship. Let's go to the PM report, PM, page 63.
When you submit that earlier 307 was lost.
Yes, 307 was there.
What is the date we are asking?
Death on 17th June.
That you say.
Death on 17th June. The PM report reveals.
So from 11th, from that means from 8th.
From 9.
9 days hospitalization.
And no dying declaration, nothing.
Perhaps the patient was not in a condition to give the dying declaration because
To that effect, anything is there? Where is the IO? Sufficient number of days.
My lord, he was in a general bed, my lord, not in a, my lord, ICU or any other critical situation.
No, he was in ICU.
In the FIR. Lord PP, you got 8 days.
yes.
You could not record the declaration of the person.
Lordship, the pertinent fact, Lordship will appreciate that after whether poison was administered or he consumed the poison without going to that debate. Lordship, the pertinent point is after taking the
There
poison.
is the question of administering when it is under 306.
No,
There is no question of administration.
previously, because section 307 was
But
previously.
you have found it to be under 306.
Yes, the charge sheet has been
You
submitted.
are appearing for the state, you are not
yes.
appearing for the complainant.
Lordship, the condition was very critical because Lordship.
Counsel,
What?
no, counsel. You have filed the charge sheet under 306.
306 and also 307.
Why not under 302?
That's the real point, pertinent question.
You will have to give the answer. Who will give the answer?
That is on part of the shallow knowledge of law, part of the investigating agency.
And for the shallow knowledge, he should suffer. For your investigating agency, shallow knowledge, we will record this. The petitioner should suffer. That is the submission of the APP.
But Lordship,
You can't just submit anything in a court proceeding. It's not a casual discussion. When you ask you something, you should come out with some plausible answer.
Lordship, one answer I have regarding the
Should we
health
record
condition.
this?
That is, his creatinine was 5.7. So from the medical report, we are noticing his creatinine was and urea was 113. That means he was not in a fit state of mind also at that stage.
Has that been noted?
That has to
Yes.
be certified by a
Is there
doctor.
a reflection to that
Yes,
in the
medical
case diary?
Yes, in the case diary.
What is the date of that report?
Not as regards to the creatinine, not as regards to the
No,
uric
what is
acid.
the date of that report?
10th,
So,
10th June.
so what happened in the 2 days preceding that 10th?
Lord, 306 and 307 cannot go hand in hand, my lord.
Cannot.
Cannot, my lord. Should not.
On 9th also,
Who is the complainant? Father? Of the
Father,
victim?
Father of the deceased.
on 9th June also the urea and creatinine was high.
My lord, whether creatinine or my lord. কি বললো? কি বললো? ইউরিয়া। ইউরিয়া।
Yes, take down. Learned counsel for the petitioner and the learned state, your state counsel or
State.
APP state counsel? The petitioner is facing Yes. As been. You are appearing in both. 65 and 66 both. Not today. Yes, you are appearing. 67. Yes. Three cases. Not today. All three cases, 67, 68, 69.
Paying for 1 day accommodation.
Yes. Number 74. Number 75. Yes. Item number 76. Item number 77. Item number 78. Yes. That's good. Next week, Monday. Monday. Number 79. Yes, that's great. Item number 80. Number 81.
Number 90. One.
None appears. In 91.
Number 92.
91 as stated.
92.
Number 92.
None appears. Yes.
For 94.
Lordship, I am for the petitioner. Lordship, I have filed this application for cancellation of bail application, Lordship. On the earlier occasion, coordinate bench directed upon the private opposite party to submit opposition, Lordship. They did not have submit that, Lordship.
Who is appearing from the
I am on behalf of the petitioner. Private Lordship, we file it by next week, Lordship.
What is the allegation? Why you want to cancel?
Lordship, the accused person violated the coordinate bench order, Lordship.
What is the instance of violation?
There is no instance, Lordship.
Lordship, there is, Lordship. I think kindly make it, Lordship, kindly make it not today, Lordship, tomorrow I'll. Violation is that the coordinate bench has directed to not to enter in the jurisdiction, and violating that, Lordship, the
I did
accused
not
person subsequently entered different time and committed several crime against the
No, Lordship.
jurisdiction of Dinhata Women Police Station, Lordship.
Lordship, I did not enter, Lordship. How did he say?
So what prevented you from filing the objection?
Lordship, this de facto complainant has lodged many kind of,
Why haven't you filed the objection?
Lordship, I have some documents. So,
What has prevented you to file the objection
Lordship,
till
there-
date?
Lordship, there is some documents I have to file it by position, Lordship. Kindly make it tomorrow. I will come with the.
Direction to file a report. And the report has already been received by the application office, Lordship. The report shows that there is a violation.
Who
It was
violation?
found
What a
roaming in the locality, and even his mother admitted that the son came to the house.
No, Lordship, this de facto complaint has lodged various times, many applications, Lordship, with regarding some other. Lordship,
Your
I
case
will,
to the direction passed the case.
I will submit the affidavit of service. I was directed, I will file.
Yeah.
Lordship, kindly be not today, Lordship. Give me a chance to file.
Grateful.
For the state. Last was the title results. All that about. Product for the state.
None appears. Next circuit.
Yes. 97. Without market, that of my want to transfer by particular to our I got it market. It was there was not a good was and now they have to start the partition. I think particular order can get two of my I afford people to sort of course and cancellation of where one of the that it was allowed and the condition that for this, for proper investigation in the case. Thereafter, we shall appear for the IO and this is officer for and further investigation in the and the order for granting an exclusive as the present constitutional campaign of the so this was the Calcutta filing. Start the copy of this notification upon the possible can be prepared with the development that because captured it for a long period of time, that's why so at one hand, she has not made with the condition by the function or something because the officer, number one, number two, not clear. How do you know that he has not surrendered? So we have not made to the officer. I gather information from the officer. We have to contact with the council. We have hosted as you are. I stand by the public servant. I am public servant.
supervisor of the particular study. I was on that particular day, I was on duty and
How do you know whether she has complied or she has not complied?
I contacted the officers, she told me that she has not complied with the terms of the order. The officer made a clear to the Lanet and registered also. I have told. This is the latest position as on today. I am told. On the contrary, she also played away from the
Where is the fact stated by you that she has not complied and how you have gathered the information? Where is this statement by you that which condition she has not complied and how you have gathered the information?
Yes, challenge the order, okay. Let him show. We are asking, he said that we have stated. So we said, let us see. Yes. That is the only ground and you have to read the entire brief now in court.
That it made the original order that the position has not been changed due to non-cooperation at the end of the acting public constable, despite having a clear stand. He may upon her by the target says that this is what. It should be mentioned here that by the institute order dated 8th of November 2024, the office constable who was elected according to the original order that was position officer by state day. Since 8 days have already been left off, but the original power magnetic function has not been specified within the original model of the particular date. So that is indicated that the date now of the this is code, that is the code that has been targeted and has not been qualified to in the original law, and therefore they include order of action. This is not bad.
Yes.
My another resident officer is that it is not an ordinary case, but it is not to manage why are you telling me? Because the similar set of offenses is continuously committing and series of FIR have been registered by many victims in the district of Jalpaiguri and other offices. I sum up the
Yes. Why didn't you move the court for cancellation? Yes. So therefore, no cancellation can be filed before a session. Then why are you making this submission? Yes. You cannot. This way you cannot. This way you cannot challenge this order. That cancellation is a different thing. Challenging the order is the different thing. So cancellation of the bail, you can go before that court. Why have you come here? Why have you come here?
Failing of which the bill shall be cancelled automatically. Only if petition has.
Unnecessarily you are traveling here and unverified allegations made in the petition. In paragraph 18 is not supported by an affidavit. You see your affidavit, you say 13 to 25 are true to the records. Which record you have referred in para 18? Show us. Come to the affidavit page, sir. Please come to the affidavit page. When we are saying something, look at it before you respond. 13 to 25, you say true to the records. Which record you have referred in paragraph 18? What is this? So casual way your cancellation of bail. We are asking you, we asked you to say, where have you stated this fact? You showed us a paragraph. That paragraph is not verified by affidavit. In such a casual manner, a liberty granted to the petitioner is to be interfered with by cancelling the bail.
Now, at one moment, she is not administrative officer, now she is not representing here also. So everything has taken right for the law and order. Not only this, I am stepping forward, I would like to put on record. There are 61 that she has got. I have got information from the district register. Not one, 61 deed she has bought and transferred the land. She's a I beg to submit the also. I don't take the administration. I am compared to say this is not an ordinary case. She has made some best series of victims. Series of victims.
Yes.
I have read other record also that she has accident.
Yes. And she has stated while taking bail that she has no antecedent.
No. Yes.
Where is that fact? Show us. Everything you are submitting only. There is no fact. You have to make out a case, then only we'll call upon them. We'll not call upon them to make out your case. Yes. So why you will not go before the court which has granted the bail? You have not answered that. Your paragraph, no, why should we direct you? Why should we direct you? You will go with an order from the High Court. That is your, if that is your intention, then we'll record that this is what you have submitted. Oh, we want to see bona fides. We want to see bona fides. Yes, yes. So where is it? Where is it? Where has she said that she has no antecedents? Everything after submission you are verifying. All three grounds after your submission you are verifying from the records. You were supposed to go through this before you made the submission, not after making the submission. When you make the submission, we ask you, you take us to a document, it is not there. It should be the other way around. You should have come prepared with all this and then told us. This is not the way. You are trying to interfere with a liberty granted to someone in such a casual way. That is why we are asking you repeatedly. Yes, you have not even verified the material and you are making submissions. How else are we to go by it? Unless you show us from the pleading, making submissions in air, is that sufficient to cancel a bail?
So that's why
But there's nothing, neither on this ground, neither on the ground of the other ground that you submitted, that she has not made available the document, that is also not verified. So both these grounds, and then you have not been able to tell us why you have not gone before the same court, why you have come to the High Court, that also you are not submitting. You are saying direct us to go. What is this?
the Honorable Supreme Court has laid down two ways.
Supreme Court will come after the facts, sir. We are trying to look for the facts which are not evident from the, yes. In absence of facts, the law will apply to a facts. Unless you show the facts, where is the question of law being looked into?
The cancellation is
All
one
right.
and the challenge is another. That's why I'm submitting that. So for the order of anticipatory bail or bail is concerned, when an order is challenged.
Counsel, do you want to proceed? Do you want to proceed here? Do you want to proceed here?
So my application and to proceed before the
If we wish, we don't wish anything, sir. We will consider your three submissions. The learned, his lordship is just asking you what you intend. You want to proceed because you had another remedy. Therefore, we are asking. We don't wish anything.
Then I'm withdrawing the application and making the application before the.
Counsel for the petitioner seeks liberty to approach the court which granted the bail for cancellation. Full stop.
My lord, this is. My lord, I am for the petitioner in this matter. This is an application for modification of the bail conditions, my lord. My lord, may I?
What condition is?
The condition is that he was granted bail by CRM anticipatory bill by CRM 700 by 2024, my lord, which I have annexed here. Annexure P1, my lord, at page 12. Just after the affidavit.
Annexure?
Just after the affidavit, page 12, my lord. This is a hard copy of the bail order.
Yes.
He was granted anticipatory bail with the condition, kindly come to the page 2, lordship. Page 2, I mean the next page, running page 13. Second part of the order, lordship. He was enlarged on anticipatory bail, my lord, with the condition that during the period of investigation or except for the attending the purpose of the court proceeding and shall provide address of the petitioner shall presently reside lordship, one second. On further condition that the petitioner shall not enter the jurisdiction of Darjeeling district during the period of investigation and or for attending the court proceeding and shall provide address where the petitioner shall presently reside to the investigating agency, and on further condition the petitioner shall meet the investigating officer as and when required, and on further condition that the petitioner shall cooperate with the investigating and the petitioner shall not intimidate the witnesses or any other residents or tamper with the evidence in any manner whatsoever. This was the condition, man. Now the accused has complied with all this condition. He is cooperating with the investigation. There is no complaint. But my lord, the accused, he is a resident of Bhagdogra, my lord. He has a business there. He has an old aging mother there, and has as a minor child. His wife is unable to manage the mother and the child together, and his business has totally been stopped. He's almost in a hand-to-mouth condition right now, lordship. Now there is another fruitful change, my lord. Another accused person was granted bail on similar conditions, my lord. My lord, here I have annexed he had prayed for an last page, my lord. He prayed for modification, and the Honorable Coordinate Bench was pleased to modify the order to the extent that he may enter the jurisdiction of Darjeeling district, provided they report to the officer in charge of Bagdogra police station once in a week till the conclusion of investigation. So this was modified up to this extent, my lord. So I am on the same footing, my lord, same case. Who accused has already got the benefit of modification, my lord. I am a businessman there. I have a business and I am unable to pursue my business and look after my old mother and the minor child, lordship. So I pray.
This is a co-accused.
Co-accused, my lord. Same case.
What is the allegation against him and what is the allegation against?
Same allegation, my lord.
What is the allegation?
The allegation is, my lord, the kidnapping, abduction, my lord. They attempted it, ultimately beating up. They had beaten up the.
Where is the bill? Where is the FIR? Let us see.
Lordship.
That both of you are
Extortion and then attempt to murder.
against both of them, same allegation.
Against all of them.
All of them.
And the order which has been modified by this order that you were just placing.
Lordship.
Where is that order?
This I have a copy, lordship. I didn't annex it. Actually, my.
Page number 23.
Yes.
No, that is the modification. Where is the original order?
Here is the original order. Again, a bail order. উল্টোপাল্টা করেছে, duplicate matter এটা
Act for the chair.
Sit in the next circuit. Please. No, no, not as paid. List in the next. None of yes, next circuit. Yes. Next circuit. Now, 102.
After the petitioner, one of the specific question there will be regarding the notification of the matter was started yesterday. I appeared online, my lord.
Yes.
The matter of NIH is correct, the application is that some fake currency was found on a portal.
Oh, that one where the earlier occasion 18 months time had been granted.
Yes, my lords. On that, I would like to submit also. My humble submission is that the said order is for infringement. The five-judge bench or judgment of the Supreme Court, which says that the time-bound direction cannot be given except in a very, very circumstance. However, the order of the five-judge bench was passed in February 2024, and thereafter the Honorable Court bench has rejected my bail order. My lord, when I look at page the paragraph number 41, 42, and 43 of the.
So why couldn't we file a application for modification? Why we filed another application? To be taken up by another bench?
That time I was also, I was not engaged.
This you have filed. So if you are feeling offended by any terms and conditions imposed in the order, we will not overlook those terms. We will not ignore those terms which have been imposed by a coordinate bench. Then you have to get it modified by the same bench, or you know what is the remedy. It cannot be done by a coordinate bench. How can you? We are not going to look at the correctness of an order passed by a coordinate bench. That's plain and simple. This is what we are saying. We are not saying it is correct. We are not saying it is incorrect. We should not be looking into it. Then you have to avail the appropriate remedy. See, you are again, yesterday also you were trying to go to the merits of the matter. We are not on the merits of the matter. We are on the judicial propriety and judicial discipline. When a particular order has been passed by a coordinate bench, you want that we should ignore it. We cannot ignore it. You want that we should set aside. We cannot set aside. So therefore, we have a jurisdiction to do neither of these two things. How can we do it? All right, as straight list in the next circuit.
Your Lordship, I am filing a status report in this case that may be taken on record.
Which matter?
This 102 item.
Involved.
তুমি রেখে দিও। ওটা নিশ্চয় আমি থাকবো।
None of you next. That I will change.
In item number 4, I am for the appellant, my lord. My lord, the appellant has been convicted by the order and judgment dated 26/9/2024, wherein and whereby the appellant has been convicted under section 6 of the POCSO for the life imprisonment.
My affidavit of service is not ready. That's why I'm praying for, my junior brother is praying for only a day's accommodation so that I can prepare the affidavit.
Yesterday also you had prayed for a day's accommodation.
yes.
So one day every day. This is the way. Give the file, let us see.
Already on the previous occasion, we had filed the affidavit of service. But Mr. Rajat Das appeared, but court directed to serve him again since he did not appear. I have served upon him, but my affidavit of service to.
So now you have served on the advocate also.
Yes, I have served upon that one.
We are informed that the learned counsel has served fresh notice upon the learned advocate in terms of the earlier order dated 6/12/2024. Stop for enabling him to file an affidavit of service listing the next circular.
Gotcha.
So 106.
Lordship, Lordship, in 106, Lordship, I am appearing for the petitioner. This is a restoration application, Lordship, and I have served upon the principal answering respondent, Lordship. On 11th, on 12th of November 2024, I have served.
Where is the affidavit?
Lordship, affidavit of service not ready. Let it be on next circuit, Lordship, in the or day after tomorrow, Lordship, I will produce.
Next circuit.
One zero seven.
108.
None appear, not today. None appear in this one Monday. Monday. With the three.
Zero 109.
My lord, in item number 109, Hirok Burman, Advocate Hirok Burman is there in this case. He's busy in election, my lord. And therefore, my lord, if the matter may be kept on Monday, my lord.
Milord, their affidavit in reply is pending since long, Milord, kindly fix us a preemptory date. Maybe Monday, Milord, let them come back with their affidavit.
Arising out of?
Milord, arising out of an order, Milord, where higher pay scale of pay has been granted in favor of the respondent. They have, Milord, questioned the qualification. According to us, Milord, in view of the prevailing notifications, that qualification is also a valid one, and the respondent is entitled for the higher scale of pay. To the application for stay, Milord, we have filed our affidavit in opposition. Reply to the same, Milord, is pending since long.
You're for the appellant.
My lord,
The state is that.
state.
District Inspector of Schools.
Yes, take down. Appellant's counsel seeks an adjournment to 23/12, full stop. We are informed that certain exchange of pleadings is pending. We direct the same to be completed in the meantime. List accordingly on 23/12.
Great.
You have deposited the cost. Have you deposited the cost?
MAT 27.
That's it. 5,000.
There was a condemnation subject to deposit of cost. If you have to deposit it.
But I was just directed to take time, my lord, that. What is it?
Number 110.
So lordship praying for next circuit.
Next circuit.
Yes.
As prayed.
Next circuit.
My lord's praying for next circuit.
As prayed. None appears.
Yes, sometime.
Not good.
Not good.
My lord, happy praying for next circuit.
Next circuit. As prayed.
Hundred 14.
Praying for next circuit, lordship. Great.
Yes.
Hundred 15.
My lord, I am for the state.
15 and 16, my lord, next circuit. And if council is there.
As prayed. Next circuit.
15 and 16.
You are in both.
No, only.
I'm for the state. 15 and 16.
Hundred 17.
My lord, item number 117. I am 117 has been called, my lord. I did not.
Yes, my lord. 170, I am for the respondent, my lord, led by Mr. Orissa Bhattacharya.
Yes. I appear for the appellate. My lord, I have, along with the appeal, I have also filed an application seeking for stay of the operation of the impugned order. I believe, my lord, the CAN application is also before my lords. My lord, by the impugned order, my lord, the order of dismissal of the writ petitioner respondent has been set aside, and the writ petitioner respondent has been directed to be my lord, resumption of service. My lord, I am before your lordships challenging the said order, praying for a limited stay. After my learned friend comes up with their affidavit, my lord can take up the main matter. My lord, if I now allow him to join, my lord, my appeal will become infructuous.
My lord, I pray for a limited period of stay so that my lord can consider the main matter on its merits.
The order is under appeal.
Order under appeal.
With the memo of appeal with the memo.
But order should be with the memo of the appeal.
You served a copy.
Yes, my lord.
Yes, my lord, we have received the copy, my lord. My lord, as per my instruction, my lord, we have to file an opposition against the stay application.
Yes.
My lord, kindly grant us time to file an opposition, my lord.
That is the reason, my lord, I was praying for a limited stay so that my learned friend can come back after exchange of affidavits.
Let him file the opposition to the stay, then we'll consider.
I'm grateful, my lord.
My lord, my learned friend has already initiated, my lord, sent contempt notices. My lord, may I seek your lordship?
There is any contempt filed?
No, my lord, there no contempt application has been
Let
filed,
him
my lord,
file
only
it.
notices has
File
been sent.
You file it by the coming week. Let the net counsel for the respond number. You are the private respondent.
I'm the respondent, my lord, only respondent. Only one respondent.
File affidavit in opposition to the CAN as well as the appeal, if so required. The opposition be filed by 23rd. You file it by 23rd, 23
Okay,
12.
ma'am. Okay.
Lord,
I'm grateful.
I take it from my learned friend that they would not be pressing for any contempt in the meantime.
There is no contempt. Where is the question of pressing or not pressing?
My lord.
Lordship. Good.
I'm grateful, my lord.
Good.
And may I have the liberty to approach your lordship's bench if certain applications are filed?
That is always there. That is always there.
My lord, your lordship is here by the next circuit. The division bench might not have the same information before them.
No. In anticipation, we cannot pass an order.
My lord. Achha.
Lordship, item number 118, I am praying for next circuit.
As prayed.
On 119, I was preparing, my lord, for lordship, because, my lord, your lordship was questioning me yesterday with regard to the indemnity bond which was submitted by the petitioner to the Indian Oil Corporation.
Can't be done in 5 minutes. We hardly have.
Yeah,
time.
I can understand. In that even will be a lordship pleasure to take it on Thursday, because tomorrow I will not be in court.
Thursday, there is a resolution.
Well, the problem is tomorrow, for my personal reasons, I will not be attending.
No, but neither my learned senior friend is a member of the Jalpaiguri bar, nor I am a member of the Jalpaiguri bar. So we both be available. If it's convenient for your lordships.
We will keep it on Thursday. As prayed, jointly prayed, list on, give the date of. Yes.
Deeply obliged, Lord. Thursday, barring Mandula, what is the time? Friday.
Hello.